In the name of Almighty Allah, the most merciful. Ms. Aroma, welcome to our session. Uh, Acquisition is the topic today, and we will be sharing with our audience the important legal terminology which is used in Companies Act 2017 and enabling regulations, whether these are corporate governance regulations meant for the non-listed companies or the listed companies. And in this vocabulary acquisition, our focal point will be to go through the terminology, which is very frequently used in this law, especially in the corporate law. And we'd like to pronounce this terminology in received pronunciation. That is a standard accent that is known as King's English as well. And this received pronunciation is the standard accent. So we will be making an endeavor to pronounce this legal jargon in received pronunciation enabling our audience and lawyers and law students to make the use of this vocabulary. And I can, in fact, emphasize the learning of this terminology at the very outset of this course, because these terms are very frequently used. And once one is well versed with this terminology, can always understand the text of law. So let's start with the very first word. Yes, Ms. Aroma.
Notwithstanding. Notwithstanding means without prevention or obstruction from or by or in spite of. It declares that a clause supersedes anything forthcoming that might contradict it.
That is right. So, notwithstanding, if I will explain this very term used in Companies Act 2017, especially in Section 2 of the definitions clauses, we will find that notwithstanding, though the ordinary meaning for this word are in spite of, but practically speaking, let's say that if there is any, any manifestation given in the Articles of Association or in Memorandum of Association, which is contrary to law, then in spite of the fact that clause is given in articles or in memorandum of association, but this the enactment or this law will hold the field, and in spite of anything given in articles, memorandum, or in any resolution passed by the board of directors, the provisions of this law will hold the field, not standing with the fact or in spite of the fact that something contrary is given in articles, memorandum, or in the resolution. Yes, Ms. Aroma, please share the second vocabulary term, please.
Repugnant. Repugnancy refers to a contradiction or inconsistency between clauses of the same document, deed, or contract, or between allegations of the same pleading.
That's right. So this repugnant, basically, this is being discussed in section, one of the section of Companies Act 2017, which provides, which discuss the overriding effect. And that precisely means that if there is anything which is contrary to the provisions of Companies Act, will be considered as repugnant or inconsistent with the law. And due to that repugnancy or something being repugnant, that will not stand in the field, that will not hold the field, and the provisions of law will be given its due effect. And due to the repugnancy or due to some clause being repugnant.
Void. Void means having no legal force or effect.
That is right. void term is used in law. That means that if some clause or some provision given in articles of association or in memorandum of association, if we call that void, that means that it is of no legal effect or it is of no legal force. And being void, actually, that becomes something which cannot be acted upon. Next, please, number 4.
Ab initio. Ab initio means from the first act, from the beginning, or from inception. For example, an agreement is considered to be void ab initio.
That's right. So right from the beginning, let's say that if there is certain clauses given in articles or memorandum of an association, and that is declared void ab initio, we can say that right from the beginning, these will be considered as unlawful, as of no legal effect, no legal force. Right from the beginning, their application will be considered as void and as of no legal effect. Next, please.
Overriding effect. The provisions of this Act shall have effect notwithstanding anything contained in any other law or the memorandum or articles of a company or in any contract or agreement executed by it, as the case may be, before or after the coming into force of the said provisions. B.
Right.
Any pro-
Yes, let's pause here first for the overriding effect. And that means that in spite of the fact or notwithstanding anything contained in any other law, that means that if there is a law which is promulgated prior to the promulgation of Companies Act 2017, and that law is in the field. Let's say, for an example, we have certain enactment introduced by the federal government, and that is still in the field, that is not repealed. And but the provisions given in that act are contrary to the enactments of Companies Act 2017, then if those both provisions, statutory provisions, are placed in juxtaposition, and it is found that there is a provision of a law which is contrary to the enactments given in Companies Act 2017, then the Companies Act 2017's statute or statutory provisions will hold the field and will have overriding effect over and above the provisions given in next is B of this point, please.
Any provision contained in the memorandum, articles, contracts, agreements, arrangements, or resolution aforesaid shall, to the extent to which it is repugnant to the aforesaid provisions of this Act, become or be void as the case may be.
That's right. So that repugnancy or that something being contrary to Companies Act, if there is any provision, that will be considered as void due to the fact that Companies Act will hold the field and will have overriding effect.